But do enjoy today's talk. It's my pleasure to introduce today's speaker, Samuel R. Gross, who is the Thomas and Mabel Long Professor at the University of Michigan Law School. Professor Gross graduated from Columbia College and earned a JD from the University of California at Berkeley. He was a criminal defense attorney in San Francisco for several years and worked as an attorney with the United Farm Workers Union in California and the Wounded Knee Legal Defense Committee in Nebraska and South Dakota. I can actually go on and on about Professor Gross, but I did promise him a short introduction. So I'll skip some of his background just to let you guys know that he teaches evidence, criminal procedure, courses on wrongful criminal convictions. He has published works that include articles and books on evidence law, the death penalty, false convictions, racial profiling, eyewitness identification, and the relationship between pretrial bargaining and trial verdicts. So you can already tell from just that snippet that he's a very interesting guy with a wealth of information that, that he's going to draw from today. So if that all weren't enough, the last thing I'll say is that Professor Gross is also the editor of the National Registry of Exonerations, which is a joint project of the University of Michigan Law School and the Center of Wrongful Convictions at Northwestern School of Law, which maintains a detailed online database of all known exonerations in the United States since 1989. And so he'll draw from that experience to talk to you all today about wrongful convictions in the United States, lessons from the National Registry of Exonerations. So please join me in welcoming Professor Samuel Gross.
What I want to do first is tell you about a particular exoneration that will set the tone of this. That person is Edward Carter. He's shown here with family members a year or two ago after he was released from prison. He was convicted in 1974. He was convicted of a very nasty, violent rape of a pregnant woman at Wayne State University in Michigan, in Detroit. He was somewhat known to the police in the area. He was a young African-American man, a talented basketball player, something of a troublemaker. He was in trouble with the law periodically. He had not been involved, as far as anybody knows, and he claims not at all in any violent crimes. He was considered a suspect in the case, and he was identified by the victim, who was white, in a cross-racial identification, in a lineup of pictures, a picture lineup that included multiple pictures of him and then a few pictures of other people. This, of course, is an extremely bad way to conduct any sort of lineup. On the basis of the eyewitness identification, he was sentenced to life in prison. What didn't come out of the trial was that blood tests on the semen that was recovered from the rape, this was before DNA testing, but you could do blood typing, ABO blood typing, the sort of typing that's done to determine what sort of transfusion you're going to get, and that was done, and the blood type was not consistent with his. That didn't come out of trial. More important, what didn't come out of trial is that he couldn't have committed this crime because at the time the crime was committed, he was in jail. He was in custody for some minor crime and wasn't released until the next day. About 2001, by which point he had been in prison for something like 26 years, 25 years, he got in contact with the Innocence Project that was then in operation at Cooley Law School, which does work on cases where DNA might prove innocence, to try to see if DNA evidence could be recovered, if there was still a biological evidence from the scene of the crime which could be used to determine his innocence, which he insisted on. And that process was a failure. They could not locate the DNA samples, the biological samples from the crime, which was at this point already 25, 26 years old. And it went nowhere. By happenstance, however, one of the police officers who was involved in the case in looking for the evidence and reviewing the evidence now decades later, became interested in it and pursued it, and eventually found other physical evidence in the case. In particular, they found a railing in the bathroom which had fingerprints on it. Those fingerprints had been taken at the time of the crime, and they did not match Edward Carter, which does not necessarily mean he's innocent. Other people could have left fingerprints there. That point was not brought out at trial either. But at this point, now several years after 2001, it was possible to do something that couldn't be done back then. Fingerprints could be entered into a national database to determine whose they were, as opposed to just comparing them to known fingerprints to see if they were a match. And they were entered into the national database, and they came back to not Edward Carter, we already knew that, but to somebody else who was already in prison, a serial rapist who lived in the area, who was in prison at that time for another brutal rape in the same area, another African-American male, but not Edward Carter. The upshot of this was that ultimately, in 2010, Edward Carter was exonerated on the basis of this DNA evidence. At this point, he had served 36 years in prison. He was released in his mid-50s. And I am happy to say he's doing very well, which is not true of all people in this situation. With any luck, he will get compensation for this, although that hasn't happened so far either. Michigan, unlike at this point half the states in the country, has no law that provides compensation, statutory compensation for people who've been wrongfully imprisoned. You have to file a lawsuit and attempt to prove that your conviction, your wrongful conviction, was caused by misconduct by somebody who might be able to pay or is covered by a county or an insurance company that can pay. The thing to notice about this, probably more than anything, is not so much why he got convicted in the face of really very strong evidence of innocence that was never presented, but how his exoneration depended on a fluke. How easy it would have been with exactly the same facts for him to still be in prison today and to ultimately die in prison. They had to have the fingerprints, and they had to be fingerprints that could be found, and there had to be some officer who decided, yeah, actually, let me check this out and follow it up, because nobody else could have retrieved the fingerprints, and nobody but law enforcement officials can put fingerprints into the national database to determine whose they are. One of our favorite 20th century creatures, I'm not sure I'd call him a human being, said that when one man dies, it's a tragedy. When 1,000 dies, it's statistics. And I'm going to move on to statistics. Most of what I have to present today is statistics. But it's really important to remember that these statistics are statistics about people. And although they're not all quite as horrifying as the story of Edward Carter, many are just as bad, and some are, if possible, even worse. I've had by now probably 20 or 30 students who've worked with me on this project, and in one form or another, as research assistants. And when they sign on, I always tell them the same thing, which is, you'll find this work extremely interesting. We do gather statistics, but the other part of what we do is research and write and tell stories. And the stories are, at the low end, interesting, and at the high end, they're transfixing. But they're almost uniformly depressing. And they're even more depressing when you realize that the story of somebody like Edward Carter is the story of someone who, in this context, is lucky. It's hard to think of that as the case, because his life was so badly destroyed. But behind every case like that, there are others. And we know this from what we can see, and I'm about to show you, probably several, maybe many, who have also been convicted of very serious crimes and who have not been identified and exonerated and who never will be. So, with that, we'll start moving on to statistics, which are never as depressing as stories of individuals. This is the website, the homepage of the National Registry of Exonerations. You see up there, 1429 is the number of exonerations that we have on the site as of today. Actually, by this afternoon, it'll be 1430, right? We have one in the queue that I have to get to when I get back to work in several hours. The number has been continues to grow. These are the exonerations that we know of since 1989. We haven't always known of these exonerations. If you look at the numbers that we have, they go like this. When the registry was released, went public in May of 2012, we released a report about all the exonerations that we knew of as of March of 2012, and that was 873. By the end of that year, December 31st of 2012, we'd added 178 cases and had 1,050. Of those 178, 58 were exonerations that occurred after March 1st of 2012, new ones that hadn't occurred by the earlier counting. But the great majority, 178, 120, were exonerations that had already occurred years, sometimes decades before, but that we hadn't known about and that we found out about by searching and investigating and researching. And that has kept going. So by the end of 2013, we'd added 231 more cases, of which 85 were new, and the remainder were older cases that we hadn't known about earlier. And by now, today, we have 1,429, so we've added another almost 150, of which 67 are new, and the rest are not. Overall, we've added, going on 560 cases. A bit more than a third of them are ones that occurred since our first report, and nearly two-thirds are ones that had already happened, but we didn't know about. There's no end in sight to this. The reason that we only have these ones, the new ones, those are the ones that keep happening. The reason we've added 557 cases, of which, 347 were new ones, as opposed to 800, of which 600 are new ones, is that we only have limited resources. We have a staff of 2, not counting me. One of them is sitting right there, Caitlin Jackson. The other one works in California, and that's it. And working quite hard, this is the number of cases we can find and investigate and code and make public. If for some reason we expanded into a larger operation, which I'm not sure I want, we'd find quite a bit more, because we have lists of research tasks that will identify exonerations that already occurred that we don't know about. And beyond that, it's really clear that there are many, many, many false convictions that occurred that we don't know about, not just because the exonerations are obscure, but because they haven't been detected by anybody. We can get back to that later if you want. What patterns can we see? Well, the website has several of these interesting graphs. These are dynamic graphs. If you look up here, they're updated automatically to the information we have at the current date. And what you see there is a graph of exonerations by whether they use DNA or not, and by year. The thing that I've noted there is that 2013, we don't actually list the ones for the current year, because for most of the year it'll be a partial year and it'll look really weird. The line will just go, will just go, down. But 2013, the last year that shows up on the chart, had 91 exonerations. It was a record number. That showed up in a report we released in February. And at that point, the record was 87. We've since learned about 4 more cases that occurred in that year. And that got a lot of attention. Here's a story from the New York Times. One of the things they mention is something I want to get back to. Nearly 1 in 5 of those who were exonerated in 2013 that we know about. These are all the exonerations that we know about. There's probably a larger group, even of the current ones, that we don't. But nearly 1 in 5 had initially pled guilty as opposed to being convicted at trial. I'll get back to that. But let me go on to the next point. What you see here is something that is often missed, at least in news stories about exonerations. And that's that a minority of exonerations involve DNA evidence. That's always been true. At the highest, point, the closest, the highest number of DNA exonerations here in 2009, the number of non-DNA exonerations was even greater. And if you look at the pattern over the past 9 years, you see a pretty clear divergence. The number of DNA exonerations is basically flat, probably decreasing a little bit over time. The number of DNA exonerations that do not involve DNA is increasing rapidly. So increasingly, as time passes, exonerations are primarily ones that don't involve DNA. This has been expected for a while, and it hasn't happened as much as people said it would, but there are other changes in the way DNA is used in exonerations. Why has it been expected? The reason that DNA is so important in what we know about false convictions is that it came as a shock to the system at one time. Starting in 1989, which is the beginning point of the cases that we now list in the registry, DNA has been used in cases where defendants were convicted in prior years, sometimes in prior decades, and the evidence in their case could now be re-examined with a technology that didn't exist at that time and that could determine with a very high level of scientific certainty whether they were or were not the person who was guilty. DNA identification does one thing. It tells you that a biological sample of some sort, blood taken from somebody's veins, or a buccal swab like that from the inside of your cheek, or blood at the scene of a crime, or in most of the exonerations that we know about, semen from a rape, whether that biological sample was left by a particular person or not. And in some cases, that establishes a defendant's innocence with a very high degree of certainty, in particular in sexual assault cases. Because if the evidence that is being analyzed is semen that was recovered from the body of the victim of a rape, and it comes from the defendant, and there is no indication or no claim that there was a consensual sexual relationship between them, that is overwhelmingly strong evidence of guilt. By the same token, if it doesn't come from the defendant, and there's no apparent other source, the victim was someone who did not have sex with anybody within 72 or even 48 hours before that, then the defendant can't be guilty. And in that context, DNA has persuaded many people that convictions that they would never have questioned were false, and that the people like Mr. Carter, who spent sometimes decades in prison, were innocent. Mr. Carter's case, it was fingerprints. but his case could easily have been solved by DNA if anybody had tried to while the samples were still available. Okay. The problem is, well, not the problem, the projected change in this is that the usefulness of DNA as a tool for exonerating innocent defendants depends on this time lag between the time of trial, when the technology is not available, and a later date when this technology becomes available. So at this point now, in 2014, there should not be any innocent defendants who could be exonerated by DNA who were convicted in the first place, because the DNA testing should be done before trial. And it usually is. Not always, but in the great majority of cases it is. And therefore there will not be, or there shouldn't be, any, or certainly not as many cases of people who are convicted of rape now whose guilt or innocence could be determined by DNA, but it wasn't done before trial. Okay? As a result, everybody pretty much said, well, this is a type of exoneration that's going to die out. There are going to be fewer of them as time passes. And that hasn't happened much so far. But what has happened is something else. If you look at this chart, you'll see here DNA exonerations over time by crime. The top line there, the red line, the top line for most of the period, the red line is sexual assault cases, rapes. The middle line, the blue one, is homicides. And what you see is that until 2008, the number of DNA exonerations in sexual assault cases was greater than that in murder cases, and other crimes are very small numbers down at the bottom, never more than 2 a year. And then the number of DNA exonerations in murder cases increased and surpassed that for rape cases, and it's remained above pretty much without a break. For 2014 so far, we have 15 DNA exonerations, and 10 of those are homicides. 3 of them are sexual assaults. And this trend is likely to continue. What does it reflect? Well, first, most of the homicides that end in DNA exonerations are rape murders. They mostly involve rape, but they're not classified as rape because the most serious charge, of course, is the murder, not the rape. Those have become the dominant group of cases in which DNA exonerations take place because of what you see on this graph. The blue line there is the time from conviction to exoneration for DNA exonerations. The dotted red line is for non-DNA exonerations. Ignore the non-DNA ones and just talk about the DNA exonerations. And what you see is that from 1989 to 2013, the average time to a DNA exoneration after conviction increased from 7 years, dipped after that down to 4, up to 19 years. An increase of about a factor of 3, nearly a factor of 3. Why? Well, increasingly, the cases that result in DNA exonerations are cases from before 1990, from before DNA testing was done on a routine basis before trial. And the ones that people care about now are overwhelmingly homicide cases, because those are the ones for which people are still in prison 25 or 30 years later. Now that's true in some rape cases, but overwhelmingly the cases in which people are still going to be in prison 25 years after the crime, 30 years after the crime, are cases in which they were sentenced to life in prison or to 30 or 40 years in prison, and those are increasingly murder cases. There is still a backlog of cases from before 1990 that involve DNA, that will be tested. And of course, there are other cases where DNA testing comes up now, where testing should have been done but couldn't be done. DNA testing is actually more complicated than anything I've mentioned. It's not a single type of testing. The DNA testing that was possible before 2003 was much less probative and was not useful for some types of very small or degraded samples. So there are technological gaps that are more elaborate than just is there DNA testing or not. It's how good a DNA test can you now do. So it's a slightly more complicated picture, but the general picture is something that that follows a pattern that you'd expect. And what ought to happen over time is that increasingly DNA exonerations will be murder cases, typically murder cases that involve rapes. And then eventually over time there will be fewer and fewer of them, but never none. Their influence on the general pattern, however, is huge, because that shock to the system, starting in the early 90s, of reopening cases that nobody had questioned and convincing people that these people had to be innocent because of new scientific technology, then reverberated across the entire criminal justice system and created an interest and a focus on problems that had been ignored, on the extent to which we do make mistakes in cases, even if they're not cases that can be solved by DNA technology. So, for example, I'll give you a simple example. In DNA exonerations, which are overwhelmingly sexual assault exonerations, the most common contributing factor that leads to false convictions is eyewitness misidentifications. We'll get to that again in a minute, but I want to focus on it in a different way here right now. Why does that happen? Well, this is a violent crime that's frequently committed by strangers. When it's committed by strangers, it is very possible that the victims or other witnesses will make a mistake in identifying the person who did it. And if they do, that person may be convicted and sentenced to very long terms in prison. A particular problem that comes up in these cases is that the people who are most at risk for this type of conviction are people like Edward Carter, black defendants, men, who are charged with raping white women, because that requires a cross-racial identification, and there is lots of evidence that people are considerably worse at identifying people of a different race than identifying people of their own race. And in the United States, that's especially true for Caucasians, whites like me, identifying African Americans, because whites have much less experience dealing with African Americans, since they're a minority, than African Americans have with dealing with whites. Even in a segregated society, African Americans have to deal with the majority of the population on a regular basis. So what you see is that going on half of all people who are falsely convicted of and exonerated for sexual assaults are African American men who were convicted of raping white victims, in a context in which that racial combination, for rapes represents maybe 6-7% of all rapes. Huge racial disproportion. Okay, but what about robberies? Robbery is also a violent crime that is frequently committed by strangers. Convictions in robberies frequently depend on eyewitness identifications. There are many more robberies by strangers than rapes by strangers that result in prison sentences. There are many more cross-racial robberies of white victims by black robbers than there are rapes of white women by black men. And yet we have far fewer robbery exonerations than rape exonerations, about a fourth as many. Why not? Well, there's no DNA for robberies. Robbers don't leave biological samples that you can then test to identify them. But by every possible standard of logic and inference, you'd expect several times more false convictions in robbery cases based on misidentifications than you would get in rape cases, except they don't get exonerated. And things like that are apparent throughout the data we collect. Okay. A couple of other things. I said I'd get back to this, and I wanted to show you a couple of versions of this so you can see something about the structure of the information we have. The number of defendants who pled guilty across the years, this basically is an increasing pattern. You see there are lines, basically, if you care about these things, basically a regression line. And you can see that the number of people who were exonerated after being convicted on the basis of a guilty plea has gone up. The overall total across cases, across all the years is about 11%. Is there an increase in the number, in the proportion of it? Well, that's less clear, because the number of all exonerations is also going up. It's going up pretty steadily. So what you have to do is look at the increase in the percent of exonerations. And there you do see that there is an increase. It's not as steep as what you look at here in terms of raw numbers, but there is an increase in the proportion. The pattern is less even, but overall you start out, with an average somewhere around 6%, although 6% is the average, but you see there's a 10% and then there's a 0% and then there's a 6% and so forth. 2014, so far, we have 11 out of 67 exonerations that occurred this year were exonerations of convictions based on guilty pleas, exact same proportion as 2013. That indicates that this is, I think, a pretty clear pattern. This is something that is changing over time. It is the case that more people who pled guilty are being exonerated. Why is that a difference? What's changed? What's happened here? My guess is that courts and prosecutors and police officers and defense attorneys, for that matter, are more willing to believe that someone who pled guilty might be innocent than they used to be. That one of the effects of the large number of exonerations that have been publicized in the last decade or two, and that some of those include people who pled guilty, is that people say, yeah, I guess it's possible, which of course is extremely true. Something like 95% of those who are convicted of felonies in the United States pled guilty rather than going to trial as a result of plea bargains. But in general, as of 25 years ago, if you had pled guilty, getting exonerated was nearly impossible. Now perhaps less so. Another item I wanted to mention, law enforcement cooperation. A lot of the exonerations that we know about involved assistance, initiative, or were entirely conducted, that was entirely produced by police officers or prosecutors or both. This isn't well known. It's not the image you have of exonerations. And it looks like the number is increasing there too. The overall proportion is going on 30%. But there, if you look at the percentage, the change in the proportion over years, you see that there is an increase, maybe, but it's a small one. That is not so much. I don't particularly trust that pattern. Our data are not so good that I think a slight increase like that is something you could trust. With more information, with more cases, it may flatten out even more. But there is something to it. The reason why this is showing, why we're paying more attention to it now is something else. These exonerations, the proportion of them may be about constant, somewhere in the mid-20s to low 30s across this entire 25-year period. But we didn't know about most of them until we started searching. The number that we knew about, scattered over all these back years, has increased dramatically over the last 3 years as we've been researching cases. A higher proportion of them, by quite a bit, was included in those 300 to 400 cases that we discovered in the last 2.5 years that had occurred years or decades before. Why? Well, because those are cases that people are less likely to draw attention to. If an exoneration is done at the initiative and as a result of work by prosecutors and police officers, they're probably less likely to call a press conference and get it on television than if it's done by an Innocence Project. That may be less true now than it used to be, but it certainly has been over time. Okay. Last thing I want to talk about, just for a couple of minutes. What causes the false convictions that lead to these exonerations? Well, for a long time, there was a basic received wisdom on this, and that is that eyewitness misidentifications were the leading cause of false convictions. And people often still say that. It's on the front page of the Innocence Project website, which is the first quote I have here, where they say 75% of DNA exonerations, but that's typically reported as all exonerations. I wrote an article in 1987 in which I said, yeah, just as far as anybody can tell, eyewitness misidentification is the leading cause of erroneous convictions. Well, I think we know a little bit more now, because this graph here, which shows the exonerations that we have as of today by contributing causes, doesn't show that. The most common cause is not eyewitness misidentification. It's perjury or false accusation. It's lying, followed by official misconduct. What gives? What's wrong here? Why are these inconsistent? Well, the answer is that the information that we now have that leads in this direction, back in 1987 we just knew far, far less about false convictions, is dominated by DNA cases. That the Innocence Project, which has done a huge amount to bring this issue to the attention of the public, deals only in DNA cases. And the DNA exonerations that they report are overwhelmingly sexual assault cases. If you look at the exoneration registry cases and break them down by type of crime, among sexual assaults, eyewitness misidentification is the leading cause, and it's at about 75%. But that's not the majority of false convictions. The largest group, 45% or so, are homicides, and then there are bunches of other cases as well. If you look at the causes, the contributing causes, this is based on data that we had at the end of last year, what you see is a very different pattern across types of cases. So for homicides, the largest group, nearly 600, the most common cause is lying by a witness or some other person, frequently by the real criminal blaming somebody else, who then gets wrongly convicted. Among the sexual assault cases, as we said, it's eyewitness misidentifications. That's true too among robbery cases, but notice, 77 robberies, no, less than a third of the number of sexual assault, adult sexual assault cases, and that's gone up as a result of a great deal of research. In child sex abuse cases, the dominant issue is not that. In the child sex abuse cases that result in exonerations, where it's a false conviction, the most common cause is, again, perjury or false accusation, but it's a different sort. In homicides, it's usually someone misidentifying the defendant as a person who committed a homicide that did take place. Sometimes the real criminal saying somebody else did it, sometimes someone who has other motives, a deal with the prosecutor or whatever. In the child sex abuse cases, it's generally a child reporting crimes that never took place. And DNA doesn't help, because child sex abuse cases, true, accurate claims of abuse, or a minority of cases that are inaccurate, are almost all reported long after the fact, when there is no biological evidence to collect, and so forth. I'm going to stop on this, but I want to make a final observation about this. It looks from this like the most common cause of false convictions is lying, perjury, or false accusations. But I don't think so. I think we don't have a clue. This is the most common cause of the false convictions in the exonerations that we know about. But the exonerations that we know about are not representative of exonerations. There are a lot of exonerations that we don't know about. For example, probably more low-key cases where prosecutors and police officers did it and didn't call attention to it. And there are many, many, many false convictions that never result in exonerations, in particular at the low end of the spectrum. The Center on Wrongful Convictions, which Jelani told you is the sponsor of this organization, is an innocence project. And on its website, they tell people that you can apply for their services if you have 10 years to run on your prison sentence. Not you've been sentenced to more than 10 years, but 10 years to go, because the queue of people is so long that they're never going to get to you otherwise. At the other end of the spectrum, there are people who are held in pretrial detention because they can't make bail, typically on low felonies, burglary or something like that, who are told, you can plead guilty and go home today, or you can wait in jail for trial in 3 months, and then you might be convicted, and if you're convicted, you'll get 5 years. Now, I suspect a lot of people in that position plead guilty and go home today, even if they're innocent. And it could well be, if we knew about false convictions at that end, and almost none of those cases ever show up as exonerations, virtually none, that you'd find out that the most common cause of false convictions is pretrial detention. But we don't know that. It's a reasonable hypothesis. The main thing you can pick out from this is that the causes are best talked about not in general, but category by category. If you think of false conviction as a pathology, it's not one disease. It's several different diseases, and how it plays out and what causes it specifically is different, from murder cases to adult rapes to child sex abuse and so on down the line. Okay, I will end on that note. I think we still have time for questions. Yes, ma'am.
I was wondering if you could enlighten our students with regards to Mr. Carter, specifically what legal processes you actually filed and used, whether in state or federal court, or the clemency judgment.
The legal process that ends up producing these exonerations is typically some type of collateral review. How it comes about varies a lot. But in a case like Carter's is in some ways a lot like a DNA case, because at the end of the day they find physical evidence, fingerprint, right, as opposed to blood or semen, which can be tested, which excludes him as the person who committed the crime. In cases like that, and that's true of a lot of DNA cases, if there is a dispute and a fight between the defendant and people who represent him and the prosecution or the police, it's typically over finding the evidence and testing it. And in most, but not all of those cases, if the evidence proves innocence, if there's a DNA exclusion, or in this case a fingerprint identification that goes to someone else who's clearly the guy who did it, at that point everybody says, okay, we got to get rid of this case. And there is, and the case is brought back to court without opposition on whatever process is available in that state. In Michigan, it's a type of motion for a new trial, a statutory motion for a new trial, and then the judgment is vacated without opposition, and then the prosecution dismisses the charges. That doesn't always happen. There are notorious cases in some places. Lake County, Illinois, was the conspicuous one for a while. They now have a new elected prosecutor who seems to have given up this practice, where their position was DNA proves he didn't do it, but he confessed, so obviously he's guilty, and we'll come up with a theory that'll show you why. And the theories were bizarre. They were sort of sick. And that happens. In that case, then you have to qualify in some manner for post-conviction review, which is either habeas corpus, a habeas corpus review, or something like that. Typically, it's some statutory provision of state law, which varies hugely from one state to another, which means that a court, frequently an appellate court, has to grant you, has to consider a petition that you filed and has to order relief. And that happens over sometimes over heated dispute in those cases. I mean, almost none of these cases are resolved in the process of direct appellate review, with a few exceptions. Occasionally in some states, and Michigan is one, you have the option of making a motion for a new trial pending direct review, and then enlarging the record to include new evidence that's presented as part of a motion for a new trial. And in some cases where that happens, you get a hearing back in the trial court sometimes 6 or 10 or 12 months after conviction, in which new evidence is presented. And some of those result in exonerations. That is the most favorable outcome you can hope for, because that means if it works out, you'll be released within a year or two, as opposed to Mr. Carter, who's decades later, you would have to claw your way to the point where somebody will pay attention. It also means that investigation and review might get done at a point in which you are entitled to counsel as a matter of law under the Constitution, because it's a part of the first direct review where you're entitled to having appointed counsel. Mr. Carter had this happen at a point where he had to write letters to people begging them to pay attention. At the National Registry of Exonerations, we get a small number of letters, like about 5 a week. And we write them back and say, we're a research project, we don't do any of this. Innocence projects, like the Michigan Innocence Clinic, get hundreds of letters a week of people trying to get someone to pay attention. Does that answer the question? It's not a happy answer.
Oh, no, I just wanted my students.
Yeah, right. Yeah. Yes.
Clearly, the total of exonerations is almost certainly a much smaller number than the number of false convictions, and I assume it's very hard to measure the actual number of false convictions other than through this imperfect measure. But I am curious about a sense of scale. You have a total of approximately 600 homicides, a total of approximately 250 sexual assaults that have led to exonerations. In any given year, decade, whatever time period you like, how many people do we convict of those crimes nationwide, just to get a sense of comparative scale?
Well, so there is one context in which we have information on this. That's this is a study which, this is not the work of the lecture, but the study that I co-authored that showed up in of this year. And this concludes that about 1 in 25 people sentenced to death in this country since 1973 was innocent. I'm actually surprised the size of that number, but I knew it was going to be somewhere in the range of 2, 3, 4%. That can be done because we have a huge amount of information on death sentences. I mean, individually, we know who's sentenced to death and what happens to them, where their case is decades later. We don't have that information on anybody else, so we cannot calculate, and there is no reason to believe that this number can be generalized to any other group, and strong reasons to think it might be quite a bit higher than false convictions for people who are sentenced to for murder but not for capital cases, or convicted of robberies or rapes or drug crimes. In other contexts, we have little bits of evidence, especially on some rape cases in Virginia, which suggest that for rape convictions in Virginia in the 70s and 80s, you'd expect it looks like an error rate in the 2, 3, 4% or higher, something like that. It's very hard to generalize. Okay, so then you get to, okay, how many cases are we talking about out there? Let's imagine that for violent crimes which people are sentenced to prison, it's 1% or 2% or something like that. How many convictions are there? Well, felonies in general. We have about 1 million felony convictions a year in the United States, but most of those aren't for violent crimes. Violent felonies, probably about 400,000 convictions. These sorts of crimes, homicides, think we have about, I think we're probably down to about 10,000 convictions a year, maybe a little less, maybe 9,000. Rapes, I'm guessing now, but I think on the order of 50,000 a year, something like that, convictions. Robberies probably about double that. I could be off. I don't have these are numbers that can be recovered from the Bureau of Justice Statistics, approximations. But so the potential numbers in prison right now, about 1.7, 1.6 million, another 600,000 in jails. So the number of people who might be in prison at this moment who are innocent, I can't see how it could be. I can't see how it could be less than 15,000 or 20,000. Even if we're down at 1%, I would probably 10,000 would be a way low ball estimate. The number. If you make any plausible estimates, given our extraordinarily high rate of felony conviction and imprisonment, it's tens of thousands. Yeah.
Yes, in the early 20th century, Sir Percival Lowell, Sir Percival Lowell was very respected.
I'm sorry, who?
Percival Lowell,
Yeah.
he was a respected academic astronomer, and he discovered and drew detailed graphs of the canals on Mars. Now, going back to your lecture, you suggested that the majority of false convictions are based on lying, and particularly with reference to child sexual abuse. But to what extent is it lying or kind of motivated false testimony, or is it the discovery of something which never occurred for other reasons, such as to explain unusual behavior?
Well, the answer is, okay, so I'm going to answer this, but I should take a break because some people have to get to class and maybe be too polite. But I'm happy to stick around and talk to people for any length of time. The child sex abuse cases come in two types. There is a batch of them that are what we categorize as child sex abuse hysteria cases, because in the late 80s and early 90s, there was this period of going after people for what were considered, there's a belief spread across the country that in particular cities that there were sex abuse rings that were doing horrible things to groups of children in huge numbers. The McMartin case in Los Angeles, which didn't result in any convictions, is the most famous, but there were a bunch of them. In those cases, the witnesses who testified, many of them came out later on and say, I lied and I knew it. But I did it because I was being pushed into it by child welfare workers, basically social workers, who would not take no for an answer, who told me what had to happen and wouldn't. Or some of them say, ultimately, I came to enjoy the role. Everybody said I was a star. I could really do, put bad people away. The other group, and the larger one, are familial child sex abuse cases. The classic ones there are ones that occur in the context of a divorce, either before the divorce or during or after the divorce. Sometimes, a bitter mother setting up, the children to testify against her ex-husband, or, children testifying against their mother's current boyfriend whom they want to get rid of, and they frequently recant later on, and then there are also the ones where you just don't know what happened for sure, and some of them are in the registry because it's a different question, but we don't judge the cases ourselves. Our criteria for what's an exoneration are how courts decide the cases. But there are definitely people who shouldn't be convicted. If you don't know what happened, they shouldn't be convicted. I think they're overwhelmingly innocent, but I hope that answers your question. But it's a hard one to answer in general, because in so many of these cases, you're talking about testimony by young children who later on will say, I would never have said that if they hadn't made me. Okay, thank you so much.